Okay, so first we'll talk about the introduction. Now, what's the purpose of FATCA? And I'm not going to be reading these slides or going over everything. I'll try to focus on the important points. The main goal is to force or induce FFIs who directly or indirectly receive money, income from the U.S. source income for its own account or for the account of its customers, to report the account's information about U.S. accounts there. A U.S. account is an account held by a specified U.S. person, which is defined. I'll get into the definition of that a little bit later, but just U.S. persons, U.S. companies, U.S. individuals, and certain foreign companies as well. And U.S. withholding agents and participating FFIs, who are FFIs who agree to comply and become part of the FATCA system, are required to withhold 30% on payments to non-participating FFIs and uncooperative account holders. And I explained to you what a withholdable payment was. It's a payment of U.S. source income. Also, in 2017, we'll kick in withholding by these same people or organizations on gross proceeds from sales of U.S. stocks and bonds. That's a later phase. This is an example of the phased implementation. And that's on the gross proceeds, even if there's no gain on the sale or even if there's a loss. So participating FFIs are those that enter into agreement with the IRS or pass certain tests to be considered deemed compliant. Non-participating FFIs are subject to this potential withholding.
Alan,
yes.
Just explain for the audience what is an FFI?
Yep. Okay. Well, let me. I'm going to defer that for a minute because there's a lot of different. The definition is a little complicated, and I'm going to skim over it when I get to the slides. It would be helpful for you to follow along, but there are several slides on what that is because there are categories of FFIs. So just let me summarize the law again so you'll get an understanding just in the sort of in the journalistic fashion. Who's responsible? Foreign financial institutions, non-financial foreign entities, and U.S. withholding agents are going to be the drivers of this. FFI agreements are going to be the main instrument of that. The FFIs need to gather information and do due diligence to find their U.S. account holders in a manner not totally dissimilar to the money laundering and know your customer kind of investigations on intake and also for pre-existing accounts. When does this begin in earnest? The effective date of the withholding is the first day of next year, but there are certain steps that need to be taken right now by financial institutions to determine what their exposure is and what level of compliance they're going to enter into. And all of this may be modified by intergovernmental agreements on a country-by-country basis, and we'll talk a little bit about that if we have the time. There is no current intergovernmental agreement with Brazil, and there may not be, so we won't be spending that much time on that. Let's talk about an FFI first, because they're the acting parties here. What is an FFI? To answer your question, it's one of these following organizations: a depository institute, except deposits also has a banking business, and the regulations list what a banking business is. Could be like letters of credit, for example. It doesn't have to be a classic bank that just takes retail deposits. A custodial institution, 20% of its income is from holding financial assets for others. I'll talk about investment entity. I have a whole other slide on what investment entities are included because it's a little bit more complicated. An insurance company that makes payments on annuity contracts or cash value insurance, which is generally speaking, not like indemnity insurance or reinsurance. It's generally something where the cash value can grow on its own through an investment component to the insurance, like whole life insurance, for example. A holding company or a treasury center that's part of a financial institution group is also included in that. So it's a very broad definition. Let me go to the next one. And so here's an investment entity. There's three kinds of investment entities. You could be like an advisor or manager that does these things for a customer, such as trading in instruments, securities, or currency, manages a portfolio on behalf of a fund, for example. So if you're the manager, you're an FFI. The fund is also an FFI as well. The second type is 50% of income is attributable to investing or trading in financial assets, and the entity is managed by another type of financial institution. Or in general, if you're like a collective investment vehicle, mutual fund, exchange traded fund, private equity, hedge fund, you're in. Lucky you. It includes managed funds. So the first category would include a trust with a corporate trustee, but wouldn't include a trust that has an individual trustee. Okay? So a family office in the final regulations that were issued last month would be, generally speaking, would be exempted unless it were managed by a professional company that does that. There's certain exclusions, but they're very limited. A foreign holding company for a non-financial group that has no more than 25% passive income, a startup company, one that's being liquidated or reorganized, so that's why it fits into the financial institution category while it's doing that. One that just engages in transactions with members of its own group, and certain nonprofit organizations. And they're treated, I'll talk a little bit about a category that's probably of a lot of interest to some of you at least, called NIFIs. This is categories except in NIFIs. NIFI stands for, and I have a slide on it, non-financial foreign entities. So that's your typical, that's a foreign entity that is not an FFI, basically, is going to be classified as a NIFI. So you got FIFIs and NIFIs. So then there's other categories of FFIs, and you're probably not going to remember most of this, but you'll get a sense when I'm done that this is just a tremendously complex law in terms of its detail, and I think that if that's your main takeaway, I think we've accomplished a lot here. So FFIs can be deemed compliant if they meet certain requirements, but they have to comply with due diligence and withholding requirements, and they have to meet the requirements for their particular class of deemed compliant. They're registered deemed compliant and they're certified deemed compliant. Registered means, just like the participating FFI, they have to register with the IRS. They get a global intermediary number when the portal opens, and I'll talk a little bit about that later. And they have to certify every 3 years as to their status. That's on penalties of perjury, just like the participating FFI has to certify also through a responsible officer in the company. Being certified is a little bit easier. You just submit some documentation to the withholding agent and that your status requirements have been met. So here's a list of registered deemed compliant FFIs, and I have slides on all of these, but they're not included because each of them have their own detailed requirements. There's a local FFI that just operates in one country under certain specific rules. There are certain non-reporting members of a group of participating FFIs, certain investment vehicles, common investment vehicles for participating FFIs, for example, certain funds whose distribution is restricted and controlled so that the risk of U.S. tax noncompliance is low. Certain qualified credit card issuers and sponsored investment entities and controlled foreign corporations, and also some categories under IGAs. IGA, again, is like an intergovernmental agreement. It's sort of like an information exchange treaty under FATCA. Just to give you an example, to make you think a little bit, there was an issue earlier in the earlier regs about whether credit card issuers would be considered FFIs. And the way they resolved it was only ones that take deposits. So in most cases, you owe a credit card company money, so that's not really an account. Although it's called an account, it's not an account in the FATCA sense because it's not an investment. The money's going the other way. So only ones that take deposits and don't have policies to refund a $50,000 deposit within 60 days would be included in the FFI category, otherwise would be exempt under this. This is just an example of one of them. Another one of interest is sponsored investment entities, and that's where it's an investment entity, so it's not a bank, and it's not a broker like a custodial institution, and it's sponsored by a sponsoring entity who agrees to do all of the financial work necessary for FATCA compliance. So the sponsoring entity must be authorized to manage the FFI and enter into contracts on its behalf. So it's not just a paper pusher for the FATCA compliance, it's actually a manager of the fund, for example. It registers with the IRS as a sponsoring entity, and also the FFI has to register also, and it agrees to perform the FFI requirements as if it were participating. And the certified deemed compliant FFIs, which is kind of a lesser level there's no registration necessary. There would be certain non-registering local banks, FFIs that only have very low value accounts, certain sponsored closely held investment vehicles, which is similar to the last category I described of registered deemed compliant FFIs, except it's for smaller entities, and something called limited life debt investment entities, which is kind of a technical group that's only going to be around until 2016. So this is if you can see the slide is a lot like the last detailed slide I showed you, except the second bullet says they have less than 21 debt and equity holders and is not an investment vehicle for unrelated parties. So it's not going to the market, it's just doing it for related parties. And then there's another category which actually may be applicable to some FFIs, where in this category it documents its own. It's not considered deemed compliant. It's a different kind of deemed compliance. It's not certified. It's not registered. It doesn't have to get a number. It provides the information to the withholding agent, and it has to provide the same information to all of its withholding agents, whether those agents are participating FFIs or U.S. withholding agents. And it provides the documentation of its U.S. account holders and that sort of thing. So now, if you're a participating FFI and you enter into this agreement, what do you have to do? Well, you have to go to the IRS portal between July 15th and October 25th and register to be sure of not having to be treated as a participating FFI by January 1st, because October 25th is the cutoff date if you need to register. Verify your participating FFI status on that website. You also, somehow they have you sign an FFI agreement, which is an agreement between the FFI and the IRS that you'll participate and you'll do all the things that are required to do. Generally, an important thing is that if you're having in a group of companies that are more than 50% commonly owned, all the FFIs in the group, it's called an expanded affiliated group under the rules, all the FFIs in the group have to register or be deemed compliant for any to have that status. Can't just register some and not register others, it's all or none. There is an exception for certain limited, till 2016, for other ones that are not permitted by local law to comply, and we'll talk a little bit, we'll have a little discussion about that. So what are the general requirements that an FFI will be doing? And I think it's fair to assume all of the big banks, and I would imagine a lot of the medium-sized and probably smaller banks in Brazil, for example, will be participating FFIs. There's no question in my mind about all the big banks because we know they're well down the path to compliance. So what are they going to be doing? They're going to be obtaining information about each account, new account starting January 1st, and they'll have a year or 2 years, depending on the kind of account, to go back to pre-existing accounts. A pre-existing account is one that's in place as of the last day of this year, December 31st. They'll have to get, in general, they'll probably be asking for documentation from all its customers, either unless in some cases they'll be able to use the existing documentation, a W-9 form for U.S. persons, a W-8 form, and there's a whole bunch of different W-8 type forms for non-U.S. persons. They'll have to verify the account, do certain procedures, get certain documentation, comply with subsequent requests from the IRS for additional information. Annually, they'll have to report on U.S. accounts and do certain reporting on accounts held by recalcitrant account holders, and that recalcitrant means uncooperative account holders that don't supply all the information that is required, and also report on certain reporting on non-participating FFIs. So the reporting is going to be actually, the first year reporting is actually 2013. The reporting is not due until March of 2015, at which time the reporting will be made for 2013 and 2014. So the reporting is not for a while, but it kicks in right away, also for 2013. Those are accounts that are in place for at the end of 2013 will need to be reported for 2013 information. I'll get into the reporting a little bit if we have time to do that. If they need to get a waiver of foreign law about account confidentiality, which could possibly be an issue in some places, such as Brazil, if there's a dual citizen, U.S. Brazilian citizen, or a U.S. citizen who's a resident of Brazil, and we probably all know some Americans who live here, then they may need to get a waiver from them in order to allow them to report the information to the IRS, and if they can't get the waiver under Brazilian law, they're required to close the account and withhold. As soon as they find out, they're supposed to do some withholding, but basically within a reasonable period of time, they have to close that account. And then every 3 years, they have to certify their compliance through a responsible designated officer in the company. The due diligence, I'm not going to get into the rules in great depth, but I'll move along here. But basically, you see in these slides, as I said, there's due diligence. There's some exceptions for small accounts. If the account is over $1 million, you can't do just electronic due diligence. The relationship manager in the FFI has to get involved and has to report. New account holders, they also have to do certain documentation on that also. And again, the new account holders, compliance begins January 1st for participating FFIs. If an account holder says the account is not a U.S. account, they can't generally just rely on that. They have to get, depending on the category of customer, they have to do some verification, get some documentation. It depends on what the category is, and there's a lot of rules, believe me. There's 500 pages of regulations. The statute is not super long as U.S. tax statutes go, but 500 pages of regulations covering much more than what I'm talking about today. It creates, I guess, a systems person would say that a new environment has been created. So, and basically, in doing this due diligence, they look for indicia of U.S. ownership, and I've listed the indicia that's actually listed in the regs there, and the follow-up on that depends on the indicia identified. And you can see stuff like U.S. place of birth for account holders. If this stuff is electronically kept on the files, they need to find it for everybody, just depending on how big the account is. Also, they need to try to relate, if their systems are such that they can relate, the systems connect related accounts between like husband and wife, or same accounts of the same person. They're supposed to consider them as one account and aggregate those. So let's move. Then the FFI reports, as I said, in March, and there's sort of a lag, and they report all this information for U.S. persons. The information reporting, the number of things that are reported are also phased in, and they haven't issued this Form 8966 yet in draft, but they've said they've actually given it a number, so it's pretty well along. It'll be issued soon so people can see. All this is going to be electronically reported. So it'll be matched. They'll be matching it. The IRS will be matching it with what the taxpayer, the U.S. Account owner, U.S. tax number is reported to the IRS will be matching it with their returns, and they will not be able to hide their money in those accounts. simply put. So recalcitrant account holders, I think I mentioned how those are handled, so I'll skip over that one. Now, how does withholding work? Participating FFI has to withhold 30% start on accounts made to an FFI. For new accounts, the withholding begins January 1st. There's a phase-in of withholding for pre-existing accounts, depending on where on the type of entity that it is. And I guess it's important to understand that there's a phase-in, and we'll talk a little bit about, I'll show you the slide that has the implementation dates. And now for non-financial foreign entities, which there's more of you in there, in that group, if you have a non-accepted non-financial foreign entity, unless it's accepted, they have to certify to their participating FFI, again, as I said, probably most of the banks and certainly all the big banks everywhere in the world, that it has no substantial U.S. owners or provides identifying information for each substantial U.S. owner. Now here's the exceptions, because there's a lot of them to this. Publicly traded entities, members of their entity group, they're exempt. Foreign governments, certain excluded FFIs, the short list I mentioned earlier, like bankrupt ones or startups, for example. Active NIFIs is probably the most important one for private companies. Excuse me. An active NIFI is one that has income consisting of less than 50% passive income and assets consisting of less than 50% that earn or can earn passive income. So if you're with an active company that manufactures something and that's your main business, and you're not an investment or passive pocketbook, and you're distributing your earnings in some reasonable manner, then you're probably an active NIFI and you're exempt. And also the last category would be exempt beneficial owners. Refunds of FATCA withholding, if you get stuck with FATCA withholding, very hard to get back, no interest for 180 days. Getting refunds out of the IRS now, I have to tell you from experience, is very, very difficult. Not impossible, but they come at a discount and with a lot of attorney's fees, unfortunately.
What do you mean is this? If a Brazilian entity is going to receive a remittance from abroad, and these remittance agents understand this Brazilian entity is an FFI, it can withhold the 30%, right?
If it's a non-participating FFI or a NIFI that does not document itself with an exemption and does not fulfill its obligation in terms of the compliance papers, or fills them out incorrectly and is subject to withholding, getting back that money means that they have to apply to the IRS directly to get the money back once it's withheld, and they also they have to do the documentation at that point. So they can't get out of doing the documentation to get the money back. They won't get any interest for 180 days, and they have a case with the IRS.
Let me give you an example. I know there are people here from insurance companies. Let's say an insurance company could not be classified, this specific one, as an FFI, since its products doesn't give anything more than indemnification. This insurance company must take any action in relation to FATCA, or no, just wait, and when it receives a remittance, it shall explain for the remittance agents that it's not an FFI.
Well, I think for all entities, this is to just kind of enlarge on that example, all entities need to do some investigation of their companies in their group to determine just how they're categorized under FATCA, whether they're an FFI or not. In the case of an insurance company, it might not fit into that category of specified insurance company, which was one of the categories I mentioned, but it could be another kind of insurance, another kind of FFI, if it collects deposits, or if it has operations where it acts as custodian. So it needs to look at that, and all companies really need to kind of do some classification of itself. Now, for most operating companies that are not in the financial area, your tax departments probably are totally aware of this, and they're all over it. They're going to take care of it. If you're not a big company and you do business with the United States, or you have some exposure to receiving U.S. source income, You need to pay careful attention and make sure that all your entities are classified so that you can respond to this if you need to submit an exemption form for withholding.
So is it possible to submit a form to ask for exemption?
Yes. You submit the form to the withholding agent. You don't go to the IRS. The only time you need to go to the IRS, unless you're a participating FFI, is if there's been actual withholding. So you want to avoid withholding. You need to do that, you need to make sure that either you're not an FFI, or if you are, then you need to figure out how you're going to comply with FATCA, whether or not you're going to be participating, whether or not you're going to fit into one of the exceptions or exemptions, and how you're going to manage your reporting. I would say the three things that need to be done soonest are to figure out your entities. That's the most important thing, and what kind of entities they are. To put together, depending on what you've come up with, to put together a plan for compliance generally. And if you are an FFI, you have to plan for your customer intake. Besides registration, you need to plan for your customer intake process beginning January 1st. That's for FFIs. For non-FFIs, you should make sure that at least your tax department is familiar with the issue, and someone in your organization needs to analyze the entities and what they do in terms of the categories of FATCA. Okay, so we thank you again. Yep. Thank you very much, and I'd like to thank all of you and Alessandra and LEC News and LEC Magazine for giving us the opportunity to talk about this.
Thank you.